That's irresponsible.
To stay safe during this pandemic. Mr. Dufresne, I wanted to come back to your initial points around the editing or the censoring of the documents going beyond the committee order. You referenced the Access to Information Act. Of course, that Access to Information Act is highly criticized. In many respects, it's a hiding Access to Information Act because of the grounds for exclusion. So I'm very interested in knowing just to what degree the government went far beyond the committee's order of July 7th, which now is obvious, and that fortunately your examination has indicated. So I would like to know how many pages were redacted or blacked out under the grounds that are wide on access to information of personal information or third-party information. How many of the pages were blacked out because of that?
I will see if I can provide that information, Mr. Julian, perhaps in terms of percentages of redactions. What we had, the ground of privacy amounted to 4%. The ground of third-party information amounted to 1%.
And this is on a basis of 3,000 pages?
5,000.
5,000. So we're actually talking about 50 pages on third party and about 200 pages on personal information.
Well, this is where the redactions, and Ms. Gauthier can correct me, but this is where the redactions appear on a given document.
Okay, thank you. And for information on the vulnerability of the government's computer communication systems and solicitor-client privilege, what percentage of the 5,000 pages?
And the Kielburger brothers,
there have been recent allegations that have come out despite the abrupt prorogation in August and the months of chaos we had in this committee due to Liberal filibusters. Very serious allegations of abuse of charitable contributions and abuse of charitable funds. Of course, it's important that committees get to the bottom of that. You've indicated that a committee that issues a summons that is ignored can report the matter to the House. The House can then deliberate and have a finding of contempt of Parliament. And you cited the case of 1913. And I think it would be, for those who are tuning in, particularly from the Parliamentary Press Gallery, perhaps germane, if you could reference that last case where there's been a finding of contempt of Parliament and what the results are.
That's irresponsible.
So the description of the 1913 case is set out in Procedure and Practice, page 132, and it indicates that in 1913, R.C. Miller, a witness before the Public Accounts Committee, refused to answer questions. This was reported to the House, whereupon it adopted a motion summoning Mr. Miller to appear before the bar and answer questions. Mr. Miller made 2 appearances before the bar and on both occasions was permitted to have counsel. He was directed to withdraw after he refused to provide the information requested by the committee. The House then adopted a motion stating that Mr. Miller was in contempt of the House and that he should be imprisoned. Mr. Miller was again brought before the bar and the resolution was read to him. And it goes on to say no private citizen has been called to the bar since 1913, and so certainly not something that we see.
Last question, Peter.
Thank you. So I certainly hope, as you do, that as we all do, I believe that the Kielburger brothers will respond to a committee summons. But ultimately, this is quite unprecedented for witnesses to say that they refuse to respond to a committee summons. And if that is the case, as you cited in 1913, there can be somewhat serious consequences.
That's irresponsible.
Well, it is something that can be reported to the House, and the House has its powers to address that.
If the House of Commons passes a motion insisting that the Kielburger brothers honor the committee's request to testify, and the Kielburger brothers refuse, there is precedent for the House to order law enforcement to imprison and compel testimony before the House or one of its committees. Do I understand that correct?
There is the precedent that I've highlighted. It is an old precedent. It is more than 100 years old. So that is factored into the strength of that.
Well, if it's old, it means it survived the test of time. And certainly we have the unmitigated right to call for persons to answer questions. And if that right is not upheld, then we as parliamentarians have a duty to use law enforcement in order to uphold it. And that is what we will do if the Kielburgers refuse to answer the questions we are asking. You have said that the government excluded from the documents it gave you information that it considered lacking in relevance. Where in our November motion did we allow the government to exclude documents it considered irrelevant?
Well, I think that the November motion was predicated on the documents that had initially been requested in July.
Yeah, that's right.
And so
I
suppose the argument would be that if it's not requested in July, it's not requested in November.
But it was requested. And what the motion said is that all documents that have been requested in July should be provided to you unredacted, with the only exception being cabinet confidences, not cabinet confidences and documents that the government considered to lack relevance. So you have still not received all the documents that the November motion indicated you should receive.
Well, it's up to the committee to interpret to interpret its motions. What I can point to is that if something is not part of the request from the committee initially in July, so if it's not relevant to the July motion, it's arguable that it was not requested.
Mr. Poilievre, Mr. Dufresne has the floor. Allow him to complete his answer. Mr. Dufresne.
I think it was complete. I think I've made it.
Allow me to clarify here. Are there a number of documents that they blacked out and handed to you covered up, and on the grounds that they were irrelevant? Is that what happened?
There were some pages where an indication was out of scope. Pages are not relevant.
Okay, how many pages was that?
I'm not sure I have that information. Let me see if I have that in my statistics. Perhaps this is something that Ms. Gauthier can provide, or we could provide it to the committee.
Come back to me on that. But the point is that we specifically decided as a committee in November to include documents that had originally been blacked out on the grounds of relevance. In fact, the government had tried to broker a compromise to exclude those documents it considered to be relevant. We refused that, and we insisted that documents and content that they had previously said was irrelevant be included for your eyes to see. That is why the motion is very clear that the only exceptions are supposed to be those found in section 69.1 through 69.3b.1.2 of the Access to Information Act. Those sections exclusively deal with cabinet confidentiality. The government was not authorized to exclude whatever it considered irrelevant. So you're now telling us that they applied an exemption that wasn't in that motion. Is that true?
Well, the ground of not relevance was not set out in the November motion. That's correct.
That's right. Because the only justifiable exclusion was if it was a cabinet confidence. Now you're telling me that the government, we're just supposed to believe them when they say that these additional redactions only dealt with things that were, in their eyes, not relevant. Well, I suspect they believe nothing is relevant. If there was the smoking gun in the Wee scandal, they would say, oh my goodness, that's not relevant. You don't need to see that. We'll just put a little bit of black ink over it. That's specifically why we insisted that you and not they be responsible for determining relevance. But you're now revealing today that they've blacked out all kinds of content, potentially whole pages or more, on the grounds that they didn't consider it relevant.
A final question there, Pierre. Mr.
Is there
Dufresne?
anything inaccurate about what I've just said?
Well, I've stated that there are some pages that are redacted on relevance.
Jeez, they've really got something to hide here, folks.
Thank you
They're going to some distance.
both. We'll now go to Ms. Zerwitz, followed by Ms. Gill.
Thank you so much, Mr. Chair, and thank you, Mr. Dufresne, for being here with us today. Maybe I'll start off just with a question on where Mr. Poilievre has ended. So in terms of if portions of documents were not relevant and they were left in, and if in fact the government provided you with all of the pages of the irrelevant documents in its possession, do you believe that it would have helped or hindered your work?
Well, I think the issue is whether the committee wants me to look behind redactions on the basis of relevance, and so that's really the determination for this committee. One interpretation would be that if it's not relevant, it's not requested at all in the initial motion, so it was never requested.
And that'll be followed by Mr. Fraser. Pierre, floor is yours.
Merci. Juste pour résumer, on parle d'un.
Just to summarize, we're talking about a scandal where the Prime Minister intervened to give a contract, a $1 billion contract, to a group that had given $500,000 to his family. So as committee, we wanted to receive all documents associated. We didn't want to receive censored and hundreds of pages of censored documents. And after obstructing us and filibustering for the longest time, the government basically said, oh yeah, we'll give you all the documents except what is in cabinet confidence. But what we're learning today is that contrary to what they said, the government did redact even more documents based on the fact that these documents were not relevant. You have confirmed today, Mr. Clerk, that the government did not honor the motion of this committee, that is to produce all these documents without redactions, and as well that there are still some redacted documents. Redacted why? Because apparently they're not relevant. And thirdly, this confirms that you cannot know if these redactions that are allegedly based on cabinet confidence is the real reason. In what I just said, is there anything you want to address, sir? Answer. Well, I believe that the point that was raised with Mr. Fraser regarding the interpretation of the November motion, in other words, was it appropriate or not, regarding the non-relevant documents. So I think that I said to that regard that in fact these documents were not within the purview of the initial motion, but we don't know. We don't know because we don't know what those documents are exactly. We don't know if that content is relevant or not because the government basically does not allow us to see what the content is, does not allow you to see what it is, so you can't magically see what is behind the redaction. That is correct. But regarding my other question, the Kielburgers say that they don't want to testify before committee, even if they are summoned by the committee. But based on a document that you produced today, the House of Commons has the right to imprison people, even though that right has not been applied since 1913. In the years immediately following Confederation, the House of Commons has ordered for the imprisonment or detention of individuals on 4 occasions. The House ordered the Sergeant-at-Arms to imprison 1 person back in 1913. I agree with you. It is certainly not our will to imprison anyone. But I just want to confirm with you in French, what you've already told us in English previously, that in the worst case scenario, if a witness refuses to testify after being summoned by Parliament, we do have the power to call upon the Sergeant-at-Arms and call upon the police forces to compel testimony. Answer. What I said is that while we went through the history of that power as exercised by the Chamber, the last time was back in 1913, and I spoke about all the other precedents prior to 1913, so it is certainly something that is not common or recent, but the House of Commons can, in fact, find that somebody acted contrary to the will of Parliament, but that is a power that has not been invoked in the longest time, and of course that would raise some questions. Yes, but how much time do I have left, Mr. Speaker?
To make it quick.
Donc, et aussi, on voit.
All right, and we see in the report as well, in the report that you shared, that back in 2007, one of the committees did exercise some of that power in the Karl-Heinz Schreiber case so that he be compelled to testify before the House of Commons. So when people say that they refuse to come before a committee, as parliamentarians, we do have the power to summon them, to compel them to testify, and it is a tool that could be at our disposal, lest they be cited for contempt. Yes, in fact, and I did speak about that precedent in the Schreiber case, who was imprisoned and who was compelled to testify before the committee.
Speaker,
Thank you.
Simple question. When he wasted 100 days in the PRC, what the hell was he thinking?
To Mr. Kelly or Mr. Poilievre? Who's on?
Yes.
Mr. Poilievre, okay, and you'll be followed by Ms. Koutrakis, I believe. Mr. Poilievre.
Can you point me, Mr. Dufresne, to an exclusion, to where in any of the motions that the committee has adopted, the government was permitted to black out information that it considered to be irrelevant?
I do not believe that's stated in either of the motions.
Right. So Mr. Fraser's whole line of questioning comes crashing down like a house of cards. He was claiming that somehow the irrelevant exclusion was contained in the original motion. It was not, as you've just confirmed. It was not included in the second motion. And therefore, the government was in no way empowered to black out things it considered to be irrelevant. And there could be all kinds of evidence of corruption related to this scandal that they consider irrelevant to the public. I mean, let's remember, this is a scandal about the Prime Minister personally intervening to award $500 million to a group that gave his family $500,000. This is the kind of corruption that puts politicians behind bars in other countries. But it's the kind of corruption that is apparently accepted in this government. And now we expect the same government that engages in these practices to have the authority to black out information that it doesn't consider relevant to the public. Well, that is not what this committee requested. Mr. Fraser personally committed to me and to this committee that the only information that would be excluded in the disclosure to you would be on the grounds of cabinet confidence, and that is a commitment that he and the government have violated, and that will have to be taken into consideration the next time we agree to a compromise with him and with members of the government. Very disappointed to learn that they did not honor their commitment that we agreed to when we passed the second motion in November. Mr. Clerk, going back to our original discussion about witness appearances, I'm going to again read from the report you gave me. In order to facilitate witnesses' attendance, the committee presented a report to the House requesting that the Speaker issue a warrant for his appearance. The House subsequently concurred in the report. In other words, a committee can pass a motion seeking a warrant to physically compel witnesses to appear, and if the House then concurs in that, the issuance of that warrant, then the Speaker would then seek law enforcement to carry it out. Is that your understanding, Mr. Dufresne?
Well, the committee would first adopt a motion to issue a summons, and then serve that summons on the witness and see if the witness complies. If it did not, then the committee could report the matter to the House, and the House could instruct Sergeant at Arms to take necessary steps.
And what would those steps include in that case?
Well, those steps could include bringing the individual to the committee or to the bar of the House.
And who would bring them to the committee?
This is something that would be coordinated with, according to the House's direction, with the Sergeant at Arms office and potential authorities. As I said, we have not seen that. The latest precedent was bringing Mr. Karl-Heinz Schreiber to testify while he was incarcerated. So a warrant was issued so he could be brought from that institution to the committee. It's a different situation.
So the Sergeant at Arms would use law enforcement in order to compel an appearance in those circumstances.
If this were ordered by the House, as I say, which it has not been in a long time.
Right, but the authority is there. That we are the grand inquest of the nation, and therefore we have the power to convene any persons for testimony, whether they agree or not.
Last question, Mr. Poilievre.
And as the grand inquest of the nation, do we have the power to compel anyone on Canadian soil to appear and testify as Parliament?
Well, you have the power to order them, and the House then has disciplinary powers if there's a breach. It could include a finding of contempt of Parliament. It could be calling the individual to the bar of the House.
Okay.